meeting of the House Environmental Resources and Energy Committee is called to order. And before we get started, if everyone could please rise, and Representative Fritz, would you lead us in a pledge, please?
United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good morning, Greg. Thank you, Representative Fritz. I could ask our member secretary to call the roll, please.
Yes, Chairman. Chairman Metcalf.
Here.
Representatives Causer, Dush here, Fritz, Lee, James, leave, McKenzie, Metzger, leave, O'Neill, Ortitai, Pyle, leave, Rapp, Sankey, Schemmel, Warner, on leave, Zimmerman, Chairman Vitale,
Present.
Representatives Committa, leave, Daley, Fiedler, leave, Isaacson, Kruger, Otten, Snyder, leave, Warren, and Zabel.
Thank you, Representative Dush. This morning's informational meeting is centered on House Bill 707. We have opening remarks that are going to be made this morning from Representative Zimmerman, Representative Kiefer, and Representative Ecker, who could all join us at the table before the committee if you'd like. So I have a few minutes of opening remarks here by the representatives, and then they all three are invited to join the committee if they'd like, if they're able, according to their schedules, to hear the information that's going to be provided by our presenters today. Welcome. You can begin when you're ready. Representative Kiefer, would you like to start off?
Sure. Thank you, Mr. Chairman. We're here this morning because I have been approached by numerous churches in my district who have daycare programs in their churches. And under new regulations, federal and then interpreted by the state, these daycares fall under the Clean Drinking Water Act, which is not unreasonable. So one would assume you would have to come in or produce tests to show that your water is safe to consume. Unfortunately, it's much more excessive than that. We have sanitation officers coming in requiring these batteries of testing that are pretty excessive. And then on top of it, they want a well certificate. And these are some very old churches. If the well isn't constructed in a specific manner, or they can't determine how the well was constructed, the water source is deemed non-consumable. They may not utilize those water sources. So we have the first church that came to me said, all of our testing shows that our water is perfectly fine, it's safe. But they can't demonstrate how this well was constructed. It would cost a lot of money to do that. And now they're told that their only alternative is to drill a new well. It's absolutely ridiculous. And then let's just say they do drill a new well and they have those resources to do it. The department is requiring that they have a plant manager. A plant manager, they'll be required to hire somebody to fill that role. So we're not saying that we don't want the water to be safe and that we don't want our children to be safe. This is excessive overreach. There's no moderation here. I have board member after board member of these different churches coming to me in tears. They're just frustrated because they feel like they're gonna have to close everything down. These are some really affordable opportunities for parents. And I'll tell you, one of the individuals that I have testifying today is from a church where my son went to the daycare program. Perfectly fine. We have never had any issues. Their water's testing fine. We are finding a solution to a problem that does not exist. So I'm hoping that we can get to the bottom of this. Thank you.
Thank you, Representative Kiefer. Gentlemen, whoever would like to start? Fight over the microphone. You have two of them.
Thank you, Mr. Chairman. Yeah, so the bill essentially exempts churches and religious institutions from the Drinking Water Act. What the bill really begins to do is respect the First Amendment rights of our religious institutions. These institutions are not relying on taxpayer funding. The facilities that they own have their own private on-lot water wells. They do test their water, and they want clean water. They want safe water for friends and family. What they want, though, is they want to take on the responsibility and the liability themselves rather than having government dictate it. And so I'm really looking forward to the testimony from some that are here today, and I'll wait on some of that. Thank you.
Thank you. Representative Zimmerman, thank you.
Thank you, Mr. Chairman, and thank you, Chairman, and the committee for letting us give a kind of brief opening statement here today on this bill. And as Representative Kiefer and Representative Zimmerman have pointed out, I also have a few churches within my district that are dealing with the same issues, and unfortunately, the one that I would have liked to attend today could not make it today. So I'm going to tell their story briefly and just to kind of give a synopsis of what they've gone through. So, little church in the middle of Apple Country, and it sits on a hill. Really rural church, provides a daycare service for it's the only daycare out there for these folks to use. And they got notice from DEP saying that we want to test your well. And the first step in that process is we need you to produce records and diagrams of the well construction, which, as you can imagine, for a well that was constructed in the 70s or even earlier, it was very difficult for them to produce these records. And as Representative Kiefer pointed out, that's a non-starter. So if you can't produce these records, you can't produce the diagrams of the well, they basically were put in a position, well, you need to drill a new well. You got to start right over. So luckily for them, they miraculously found some of these records, so they were allowed to go through the process of actually testing the water. So went through that process. That cost them roughly $3,000 just to go through the testing phase of things. And they want to do the right thing. Again, they want to have clean water for their children, for the people that go there. And the water came back. The water came back, and as we could expect, was not up to snuff with, and was not approved by DEP as far as the testing was concerned. I don't know exactly what was in the water, but there was some trace of bacteria, some type of trace of bacteria in the water, which caused them to have to correct that problem, which they willingly did. Small little church, we're talking about a church here of less than 500 members, not a very small church. So they agreed to fix the well, go through that process. The equipment to fix the well and the water treatment system is going to cost this church about $15,000 to $20,000. And so they went through that, went through the testing, and did that. Come to find out that they also have a parsonage that's attached to the church, and the parsonage is occupied by the current pastor. Basically a private residence, but it is owned by the church. And in going through the testing, the DEP basically informed the church, well, we need to also test that well. That well also needs to be, it was a separate well from the church's well. However, because it's owned by the church, the DEP said that, well, we need to fix that well as well. So this is a property that is occupied by essentially a private citizen, somebody who is just like the house that's right next to the parsonage. It doesn't have to go submit to DEP testing, but because it's owned by the church and because it's associated with the daycare, the church is required to fix the pastor's well as well. So and all these things, we want people to drink clean water, but for in this instance, this is basically closing the doors on this church because, as I said before, this is not a very large church. We're talking less than 500 members, and honestly, probably less than 100 folks that show up every week, and that's an additional $10,000 to $20,000 just to fix that well as well. So we're talking significant monies for these churches. that do care about their people, but don't have the means to, correct some of these problems, especially in this case where the parsonage is really, I think, beyond the reach of what what we're seeking to correct here. So, I appreciate the opportunity to give my story for Uriah today, and thanks for the opportunity.
Thank you all. As I said, all of you are invited to join us if you'd like. You have time. You're welcome to stay and join the committee. So we have a panel of presenters this morning for our first presentations. It's on that panel will be Ms. Dottie Schultz, Council President with Christ Lutheran Church, Phillies in Dillsburg. Debbie Mahadi, the pastor from L. Oh, they're not speaking? Okay. Jonathan Zimmerman, Weaverland Conference Schools, Darrell Sensing, Little Britain Mennonite School. So Ms. Schultz, Mr. Zimmerman, and Mr. Sensing? Sensenig. Thank you for joining us.
Thank you for inviting us.
You can begin when you're ready.
Good morning, and thank you for allowing those of us affected by the new DEP regulations an opportunity to voice our experience and concerns. I am Dorothy Schultz, Council President of Christ Lutheran Church Filey's, Dillsburg, Pennsylvania. I, along with our property chairman and the directors of the Learning Center, our child care facility, nursery school, have attended all the meetings with the DEP sanitarian.
Ma'am, if you could just pull your microphone a little closer to you, if you
Certainly.
wouldn't mind there. It's just there's cameras rolling. I assume we're streaming. So thank you, ma'am.
I have handled all the correspondence and notifications with DEP, while the property chairman has done the testing and any work required by DEP. Our churches, we have a second congregation that uses our facility in the evening, on Sunday evenings. The Learning Center and Nursery School are nonprofit organizations offering Christ-centered services to our community. Both the Learning Center and the Nursery School, as part of their mission, provide a Christian influence in the care and education of their students. And until our meeting with the DEP sanitarian on December 2018, we were unaware of the changes in the regulations for wells used by churches and daycare facilities. The Learning Center completed a questionnaire from DEP in December of 2017 about the source of the water they were using. This request did not include any information about why the request was made. Our first follow-up contact with DEP was in late November 2018, when the Learning Center director received a phone call from the DEP sanitarian in charge of our area requesting a meeting. At that time, the DEP sanitarian informed us of what would be needed for the meeting and indicated there was a possibility that the water would be shut off on that date if well certification papers were not made available. The meeting was scheduled for December 5th, 2018. Our church records were destroyed in a fire in 2010. We did not have the requested well certification. Fortunately, one member remembered approximately when the well was dug and by whom. When we contacted them, we found the original owner had passed the business on to his grandson. Unfortunately, their records were not computerized, and without the dates, they would not be able to find the records. It was impossible in the 2-week period provided to get the well certification papers requested. At the December 5th meeting, we were served a do not consume order, even though we had been using the water since 2002. Over the years, the water was periodically tested. These reports detected only minor problems, which were resolved by installing a sediment filter and ultraviolet light. We requested permission to test the water again, and if the tests were within the accepted limits, to use the water while the well was being certified. This was considered by DEP as unacceptable. We immediately replaced the well cap at DEP's request, but the ultraviolet system was not replaced pending the results of the water testing. Once the well certifications papers were submitted, we needed to complete a 12-hour water test to receive a permit for the water plant. Through prayer and patience, we have almost made it through the certification, permitting, and testing. To date, we incurred the following expenses. The well cap replacement was $52, which my husband did the installation, the property chair did the installation of at no cost. The 12-hour pump test by a certified well driller was $2,700. Water test at the end of the 12-hour test were $2,400. A water flow meter was installed at a cost of $32, but the meter was donated to us, and the property chairman made the installation at no cost to the church. The expense was for some parts that were needed for the installation. Our daycare incurred a $600 expense for using all disposable materials during that period and buying some water. The other 3 units used bottled water for that period at a cost of approximately $55. Regular tests so far this year, since we've progressed to the next stage, have been 154. So our total costs to date have been $5,993. Since we are so close to certification, we only have 1 test to go that is not cleared. DEP has started us on a permanent and regular testing schedule included on our timeline that I supplied with everybody. The cost of these tests for the remainder of the year is estimated at $4,865. We will also have a permit fee of $50 or $600 depending on the final total dissolved solids test, which is the only test that has not come back within approved levels. During the period when we were under the do not consume order, all 4 entities were required to purchase bottled water for all uses other than the restrooms and hand washing. The Learning Center could not use the dishwasher, so they had to serve meals with disposable materials, which added to more overflow in landfills. All the food preparation, cooking, and cleanup had to be done with bottled water or water from a source other than the church. Their expenses during this period increased by $600, plus the inconvenience of filling and transporting a 5-gallon cooler of water from another source. These expenses and the continuing cost are for a population of 135 people served by our well. Less than 50 students and teachers are there 5 days a week for 8 hours or less. The remaining people are there for much shorter periods, and many just once a week. It is questionable how much water they consume during their time at the church. Many of these people come from homes that are also served by non-certified wells using the same underground water source. Once we receive our permit, we are required to hire a certified plant operator to maintain our system, collect the water samples, and take the samples to the lab for testing. This will cost us at least $2,000 a year, or considerably more if we are required to install a reverse osmosis system to treat the total dissolved solids problem. The church's income is dependent upon congregational donations, and like most churches, we have a very tight budget. We have 2 paid employees, the pastor and a part-time administrative assistant. All other positions are filled by volunteers. Adding $9,000 or more to our yearly budget will be a burden, and will it adversely affect our mission to share our resources to help those not as blessed as us? We do not want to serve tainted water to the children, congregation members, visitors, and employees, but are all these tests necessary to assure drinkable water? We question whether this frequency of testing is also necessary. There are churches in our area who have not been as blessed as us with a new building and a well that can be certified. Our daycare facilities provide affordable daycare services to the many families in our community. Where are these families going to find new facilities to care for their children at an affordable price they can afford, and a price so that they can continue working and providing for their families? Relief of some form is needed to help the churches and daycare centers served by wells meet the regulations while still being able to afford to provide these for these children, their families, and our faith communities. Thank you for taking the time to hear our story and to listen to our concerns.
Thank you. Gentlemen, you both have testimony that's about just as long. We're going to kind of be on a tight schedule, so if you're able to kind of share with us in your own words, in addition, if you want to summarize your testimony, or so we can get some Q&A time.
As I was running over, I thought I would be with
No, you're fine. You're fine. Just we're having 3 people on the panel, but if you're able to go through. We have about 13 minutes left for 2 of you.
Good morning, Chairman Metcalf, Minority Chairman Vitale, and ladies and gentlemen of the committee. I want to thank you for taking time out of your busy schedules to attend this hearing on House Bill 707, and I appreciate the privilege to come before you to plead our case. My name is Jonathan Zimmerman, and I live in Denver, Lancaster County. I have 5 daughters that have either attended or are attending a private Christian school in Penn Township, Lancaster County. I was also a board director at their school for 6 years. I am a plumbing contractor by trade, and I have worked in both the residential and commercial sectors. My testimony today will pertain mostly to the experience I had with the Pennsylvania Department of Environmental Protection at the school my children attend. However, I am here also as a spokesperson for 11 other private schools located in Lancaster, Lebanon, Berks, Perry, Juniata counties. The school my children attend has 32 patrons, 69 students, with 6 full-time teachers, a tutor, and a teacher's helper. It is a 6-classroom facility with a basement and a small kitchenette. There are 4 restrooms with a weekly water meter reading averaging around 60 to 100 total gallons daily when school is in session. We have no showers, no laundry, no commercial kitchen, no dishwashers or other large water usage items. We had our first initial contact with a DEP official around 2010 when he stopped in uninvited and unannounced at our privately owned school and knocked on the door. I want to stress that unknown individuals showing up at the school created an ominous concern for the teachers, as I must unfortunately remind the committee. The nickel mine shooting had, at that time, occurred only 3 years prior. The official proceeded to tell the teacher who answered the door that the school was in violation of the PA Safe Drinking Water Act and needed a school representative to contact him. After a representative contacted DEP, and while the school directors were trying to determine the severity of the claim, DEP began sending letters to the school threatening to penalize the organization with indictments. The school agreed to set up a meeting with DEP in the Lancaster office on March 3rd, 2011. 2 school representatives, including myself, met with 6 DEP officials who made us feel outnumbered and intimidated. DEP coerced us into signing a consent order and an agreement under duress, with the threat of having to close the school until the case was resolved. We also signed an appeals waiver under duress. We felt this was in violation of our constitutional due process rights, since they threatened the school with penalties before the organization was found guilty of any crimes. Along with the consent and order agreement, our school was required to take a new source water test where approximately 90 different items were tested. These tests cost the school close to $2,800. In addition, the Department of Environmental Protection required us to have our existing water pressure system, which was installed when the school was built in 2004, drawn by an architect and stamped by an engineer firm, causing further financial hardships. Our school went from having a private-owned water well system to a school that is a non-transient, non-community supplier of water. Our school of 32 patrons and 69 students has to follow the same water sampling and testing procedures as a public school or a municipal water supplier, both of which would serve significantly larger populations. This is in spite of the fact that the United States EPA has in their summary of Safe Drinking Water Act stated that drinking water standards only apply to public water systems, not private individual wells. With a public water ID number, we required to contract a DEP certified operator to run our water system, impeding our ability to even work with a business that we trusted. Our school is now compelled to follow a stringent and very confusing schedule of water testing. At first, some tests were only every 3 years, but soon became yearly and eventually quarterly. Over the following years, the testing requirements continued to intensify to the point that several of the tests must be conducted monthly, weekly, and in some cases daily. Even after multiple and consistent negative test results, DEP does not allow for either the reduction or the elimination of those testing requirements. The DEP also has special requirements on water purification equipment and water testing equipment. While many ultraviolet light systems have passed the UL testing, the DEP still forces the removal of those bacteria-destroying devices and requires the installation of contact tanks, which increase the weekly and daily water cost testing. We are spending thousands of dollars a year in water testing and other regulatory costs, even though no additional problems have been found. I'm going to skip to my conclusion here if we're short on time. In conclusion, the DEP contacted our school in 2010. Since we have paid $25,000 in water testing and water-related equipment. The testing costs and requirements continue to rise with no end in sight and no reprieve from the DEP or the Commonwealth. The other 11 Weaverland Conference schools I represent today are facing very similar circumstances. Ladies and gentlemen of the committee, I urge you not only to favorably vote on House Bill 707 in this committee, but also to present it to the entire House floor for consideration. With the ever-rising costs of unnecessary water testing, please help move HB 707 along and support relief before private schools are forced to forever close their doors to an overzealous government agency. Thank you again for your time and the opportunity to provide input on this issue.
Thank you, sir.
Morning, Chairman. My name is Darrell Sensenig, and I live in Quarryville in Lancaster County. I have 6 children that have or will be attending a private school in Little Britain Township. And I've been a board director there since 2008. And a lot of what I'm going to be saying is similar to what Jonathan just read, so I'll try to summarize. My testimony pertains to our school specifically, and we are a very small school. We have 18 patrons with 42 students. We have 3 full-time teachers, and as well a full-time teacher that tutors and assists the other teachers. Our school is just a 3-classroom structure with 1 set of restrooms, and we also have a separate building with a kitchen, a common area, and 1 set of restrooms. This building is primarily used by the students for various activities. It is occasionally used by members of the community for family gatherings. So our initial contact with DEP was a phone call to the school, and they set up a meeting with us, and we were informed that we were in violation of the Safe Drinking Water Act. So we go through some timelines there starting in May 2010 that we were forced to sign the consent order and agreement. And at that point, we were required to contract a certified operator. We also had to hire an engineer to design and stamp a water system that was approved by DEP. On completion of the engineering, we realized that our small school did not have adequate space to house the water treatment equipment required. we were forced to build an addition to the basement of the school at a cost of $11,400. We then proceeded to install the water equipment required at a cost of $13,500. Just summarizing, as we went on there, we also have to do a daily testing on our own and then report those results to DEP monthly. This in itself is a burden as it requires approximately 70 hours annually of a volunteer's time to do that daily testing. These costs are shared by the patron body, and we are thankful to God that we are able to send our children to a private school, where in addition to a good education, they are taught our Christian values. However, our tuition continues to rise in part because of these exorbitant water testing fees. This makes it very difficult to continue to operate a small private school. Since DEP contacted our school in late 2009, we have spent $25,000 on construction of water room facility and the water treatment equipment. The initial water testing fees from 2010 to 2012 was $7,600, and subsequent water testing and maintenance has totaled $20,500 since 2013. This has created a substantial financial burden on our small school. In conclusion, House Bill 707 is a religious exemption bill that fits with the intent of the First Amendment of the United States Constitution. Our school is a private institution that is managed by individuals of similar faith and backgrounds who wish to express their sincerely held religious beliefs through the education of their children. Our school is an entity that is reliant on private funding streams, not public dollars. We simply wish to exercise our religious freedom and manage our religious institutions without oppressive government interference. Ladies and gentlemen of the committee, I urge you to vote favorable on HB 707 and present it to the House floor for consideration. Thank you for your time.
Thank you, sir. And Mr. Zimmerman had cut his testimony a little short because we were running a little behind to get your testimony all in and to have any time for questions and answers. We have like 2 minutes left. But part of what you skipped, Mr. Zimmerman, in your testimony was you're citing the Constitution of the United States and the Pennsylvania Constitution, which I think was very appropriate for being included in your testimony this morning. So thank you for including that.
Thanks for
in your
bringing it up,
testimony
Chairman.
Representative Zimmerman, you have a quick question for our guests today?
So if I'm understanding it correctly, maybe to all of you, so from your initial contact by the department, and they kind of required that you do some things and make some fixes with your water system, and the whole testing issue, are they continuing to ratchet that up? Is that what I'm hearing? From the initial onset of needing to test, you now need to test more routinely, more often. What are some of those tests that you need to be doing, especially like daily? What's that include? Okay, the daily testing is chlorine is the main thing they're looking at, chlorine and nitrates. Or as we have a chlorine system, and they want to be sure that there is always chlorine in that water. Okay.
That's the same. We test weekly for nitrates at our facility,
Okay.
and chlorine would be daily.
So far, we have no weekly tests. We have monthly chloroform, and we are now starting. We are actually just in the starting. They've been actually doing this a lot longer than us. We've actually just started regular testing, and I think I listed that on my timeline, the list of what they are. But the monthly one is called chloroform. It's for bacteria.
Okay. Thank you.
We're kind of out of time for any additional questions. Representative Dush, when you signed the consent decrees, did you have legal counsel involved representing you or working with you before you signed those consent decrees?
We did not, no.
Actually, we didn't even know what was involved in the meeting. I mean, they just set up this meeting, and when they arrived, they immediately, when we couldn't give will certification, we had to sign the decree for do not consume.
I assume you've had interaction with the Department of Education over the years, operating schools.
I'm representing the church because we own the well. Our daycare does have it, and it's interesting that that was one of the tests that they are not required to do, was test water. Of all the tests that DPW requires, water testing was never one of them.
I'm sorry for the trouble that your churches have had to go through with the state. I think your citation of the Constitution was very applicable, and sitting here listening to your testimony this morning, it's frustrating to hear that any entity under state government would think that they can come into a church and essentially have an avenue to shutting it down for operation, because they can come down and shut down your well and shut down the ability for you to even worship there. So thank you for being here for today, and we'll look forward to working with Representative Zimmerman on his legislation.
Thank you, sir.
Thank you. Our next presenter is from the DEP, Ms. Lisa Daniels, Director of the Bureau of Safe Drinking Water. Thank you for joining us. You can begin when you're ready, ma'am.
Thank you. I'll start off by saying I do have a cold today, so please let me know if you have any trouble hearing me, and I'll do my best to speak up, so thank you.
Thank you.
So good morning, Chairman Metcalf, Chairman Vitale, and the members of the committee. We certainly thank you for the opportunity to speak with you today about the Commonwealth Safe Drinking Water Program. Again, my name is Lisa Daniels, and I'm the Director of the Bureau of Safe Drinking Water within the Pennsylvania DEP. Safe Drinking Water staff are on the front lines every day ensuring our safe drinking water is safe and it's protected, and that we're protecting the health of all Pennsylvanians. Just a couple of things I want to speak about this morning. First of all, I want to give you a little more information about our Safe Drinking Water Program so that folks have a better understanding of what we do and sort of why we do it. I'm going to talk a little bit about the scope and the applicability of the Safe Drinking Water Act and regulations, because folks have to understand sort of what that language is and who it applies to, and then I will get into a couple of potential impacts from House Bill 707. So just starting with a very few brief facts about the Safe Drinking Water Program. We believe the Safe Drinking Water Program is vital to maintaining healthy and sustainable communities. Proactively avoiding incidents such as waterborne disease outbreaks can prevent loss of life, reduce the incidence of illness, and reduce healthcare costs. That's been a proven fact. Proper investment in water infrastructure and operations helps ensure a continuous supply of safe drinking water. It enables communities to plan and build for future capacity and ensures their long-term sustainability. So that's sort of the foundational aspirations of the program. In total, we regulate just something under 8,400 public water systems. So we have a lot of public water systems in the state, and in fact, we rank third in the country in terms of the number of public water systems. And I'm going to be talking about sort of the breakdown of those. But these public water systems provide drinking water to 11.3 million people, which is 89% of our population. Of course, the remainder of that population gets their drinking water from private wells. When we look at the number of public water systems in the Commonwealth, they're broken down by a couple of different categories. These categories matter because it's what dictates the level of regulation these facilities receive. So first and foremost, we have community water systems, and we have almost 2,000 of those. Those water systems serve residential populations, and so there's lots of opportunity for those folks to ingest water, use it in other ways that are considered human consumption, and so there's a lot of risk for those folks. The next level down are what we call non-transient, non-community water systems. We have a little over 1,000 of those. And from what I could understand from the various folks that testified right before me, it seems like most of them fit in that category. Non-transient, non-community water systems serve the same people. It's usually on a Monday through Friday basis, but there's a lot of opportunity for repeated exposure to water. This is our businesses, this is our schools, this is our daycare centers. So there's still a really good opportunity for them to be exposed to something in their drinking water that could make them sick. The third level that we have are transients. These are restaurants. These are the bulk of our water systems. You'll see in the testimony there's over 5,000 of those. They have the least exposure to water because they come and go. So those folks have the least amount of requirements applied to them In that case, we're just concerned about the acute contaminants like bacteria and nitrate, for example. So the way the regulation is structured and the way the Safe Drinking Water Act is structured, the level of requirements, the level of protection matches the level of risk in terms of being exposed to drinking water. One thing I will note is the Commonwealth does not have private well standards, and a lot of you are aware of that. We are only one of 2 states that does not have private well standards. What that means is consumers of private wells have a greater risk of being exposed to contamination because private wells with no construction standards are more susceptible to shallow surface water and other contaminants that are going to be in the upper layers of the soil. And so that's a fact that we have to deal with within Pennsylvania. Getting to the scope and the applicability, I'm going to keep this really short. We've provided the citations within the testimony, but we have a delegated program in Pennsylvania, which means we are held to certain standards that come directly from the Federal Safe Drinking Water Act and the regulations. 2 criteria for us to retain primacy for the program or primary enforcement authority include that we have to have a program that is at least as stringent as the federal rule. And that includes every part of this Federal Safe Drinking Water Act and regulations, line by line. We have to match up exactly, and we have to be as stringent. Once we have a program that is as stringent, we have to agree to continue to implement it as it was intended. Those 2 conditions get checked on a routine basis through EPA audits. There are also provisions within the Act that say, though, at any time the administrator, the EPA administrator, becomes aware of a state that is not meeting those criteria, that the administrator can make a decision to begin with the withdrawal process of primacy. So there is absolutely a process in place where a state can lose primary enforcement authority if we are deemed to be not as stringent as EPA, and that's something really important to keep in mind. The only other thing I'll say about the applicability right now is there's a very clear definition in both the federal and state acts and then also the regulations that define a public water system. And except for Pennsylvania adding in language for bottled water and vended water systems, the rest of that definition is identical to the federal definition. So currently our definition is considered as stringent as the federal rule, but if that definition is changed, it could certainly make us less stringent. There are just a few exemptions under the federal and state rules that allow somebody to be exempt from the Safe Drinking Water Act. They're pretty clear. Essentially, though, if anybody has their own source of supply, they don't meet that exemption, provided they meet the other criteria, which is serving 25 or more people, serving 15 or more connections at least 60 days out of the year, which again goes back to the basic definition of a public water system. Getting to the real points we want to make here, there are potential impacts from House Bill 707. So first and foremost, as I said, this amendment would change the definition of a public water system. It would add an exemption for religious facilities. So a couple of points we want to make about this. First of all, we believe all consumers of public water systems within Pennsylvania should be guaranteed safe drinking water. We absolutely understand that some of these facilities are serving services that are very much needed in the community in terms of child care, potentially elder care. But these same individuals represent some of our most sensitive subpopulations. So in terms of protections, children and the elderly need more protection, not less, when it comes to safe drinking water. They certainly can exhibit a higher incidence of illness because they are more susceptible. In our testimony, we just mentioned a couple of the more well-known waterborne disease outbreaks that we have seen associated with drinking water. The 1993 Milwaukee outbreak resulted from cryptosporidiosis contamination that sickened over 400,000 people and resulted in dozens of deaths. A smaller one, which was associated with a groundwater system in Walkerton, Ontario, that organism for that outbreak was E. coli. Again, it sickened thousands of people, and it caused 6 deaths. And in this case, the deaths were the young and the very old because they're more susceptible. So we believe these populations deserve the protections afforded to them under the Safe Drinking Water Act. Point number 2, if we exempt one particular sector of the community, it could certainly raise environmental justice issues and concerns. So that's something to keep in mind. Number 3, the bill would certainly result in the Pennsylvania Safe Drinking Water Act being less stringent than the federal Safe Drinking Water Act, which absolutely could jeopardize primacy. As I mentioned before, EPA would have to begin the process to withdraw primacy if it was deemed that we were less stringent than the federal act and regulations. There are consequences if we lose primacy, and I just want to briefly tell you what those are. Number 1, if we lose primacy, EPA will withhold all federal funding for the Safe Drinking Water Program. This includes the $4 million that we currently get from the PWSS fund and $20 million we currently get from the SRF fund that partly goes to run our program, but the bulk of that funding goes to PennVest for infrastructure funding. All of that money would be pulled back because EPA would need to use that money to run the program themselves. And so there would no longer be any funding available through the PennVest program or any other water system across the state to fund infrastructure projects, and that's a reality if we lose primacy. Number 5, and this is something that folks really need to understand. If the Safe Drinking Water Act for Pennsylvania was amended to exempt religious facilities from state regulation, these facilities would still need to comply with the federal Safe Drinking Water Act, and there is no such exemption in that federal act. So let me say that again. If you remove it from the state's Safe Drinking Water Act, it does not relieve them from having to meet the criteria under the federal Safe Drinking Water Act. And remember, if we lose primacy, EPA is the agency that comes in and runs the program in Pennsylvania. So I don't think this gets what you need, because they would have to very much comply with the federal Safe Drinking Water Act, and there is no such exemption under there. And more importantly, everybody else that didn't get the exemption would still have to comply with both the state and the federal regulations. So we would be setting up a situation where there would be dual oversight of both EPA and DEP for the bulk of our systems. And again, I'm not sure that's what you intended to do. So in our opinion, we don't think this bill really achieves the goal that you're looking at. It would unnecessarily complicate things for most of the water systems because they would have to deal with that dual oversight. And really, getting rid of the state requirement does nothing to get rid of the federal government. And so instead, I think we'd like to talk a little more with you about what we can do, maybe through the arena of technical assistance and training, to give this sector maybe some additional assistance in complying with the regulations. So that's what we wanted to share with you today, and I'd be glad to take any questions you have.
Thank you. The definition that the DEP is claiming that these churches are falling under, when was that definition adopted in the law, do you know?
So the basic definitions for public water system and the various types go back to 1984, the very beginning of the Safe Drinking Water Act when it was
That was my
promulgated.
understanding. It was from the 80s. So when did the DEP start hassling churches to require this?
So we have always regulated churches, all churches, as public water systems. So we routinely find new facilities that aren't on our inventory. We usually find about 100 new water systems each year. We go through a list of questions to figure out whether or not they qualify. If a church only has Sunday service and they don't have a daycare center, they don't operate any other activities through the week, then the good news for that church is they don't qualify because they're only open 52 days a year, not the required 60. So in a lot of cases, churches do not get regulated by us because they fall under that 60-day time frame. But where we come across a church that is operating a daycare center, and again, remember, children are our most sensitive subpopulation, they generally do meet the criteria and need to be regulated.
So you're claiming that this has been enforced since the 80s?
Absolutely. So I don't have the numbers off the top of my head, but I can give you a list of daycare centers and churches that have been regulated since the 80s and 90s.
I would appreciate that
Sure.
information being sent to the
Sure.
committee, to my office, and we can distribute to the
Absolutely.
committee. Representative Vitale.
Thank you, Mr. Chairman, and thank you, Lisa, for testifying today. And I just want to commend the DEP for
your committed staff and the great job you do, given the fact that you aren't getting the assistance you need in terms of adequate staffing. So I wanted to touch on the point you ended with, which is additional assistance. And I know historically that you've been cited by the EPA for your lack of staffing and your lack of ability to inspect drinking water systems frequently. So I want to kind of zero in on this. I want to talk about, with regard to the Bureau of Safe Drinking Water, the current amount of staffing you have, the staffing levels you had when you were at full complement, and optimally, in a perfect world, what sort of additional staffing would you need moving forward?
So thank you for that question. There is no doubt that we had been understaffed. From 2009 up through last year, our staffing numbers in the Safe Drinking Water Program were down by 25%. We absolutely were not getting inspections done on time, and a lot of other work was being delayed. And if folks were following along at all with our drinking water fee package, we shared the various letters that were written by EPA to us, putting us on notice that they were very concerned about our program. The good news about all of that effort is that we were successful through our drinking water fee package to get the funds we need to hire 33 new staff. That process, that hiring process, started last year, and I'm pleased to say that we're almost finished filling all of those 33 positions. So we should be in pretty good shape in terms of staffing levels from the field perspective, in terms of getting inspections done, getting permitting and planning reviews done on time. Right now, the only sort of gaps we have in our program are to sort of deal with a new and emerging issue called PFAS, if any folks are familiar with that title. And then also, we at times struggle to deal with our water allocation program, but the rest of the core program is really in pretty good shape.
Okay, so give me some quantitative numbers with regard to where the number of staffers your program had in either 2009. I kind of cite 2004 as some former DEP secretaries do as your last time you were at full employment. Could you tell me what your numbers were in 2004 versus what they are now, or the numbers when they were optimal versus what they were now? I mean, and how that 33 affected those numbers.
Sure. The best way I have found to describe sort of where we sat in terms of being able to get our work done is really based on a ratio. So in the worst of times where the cuts were really bad, each of our sanitarians was responsible on average for at least 140 to 170 public water systems. That workload is unattainable. You cannot get your inspections done. You cannot oversee compliance monitoring for that heavy of a workload. So that was as worst as it got in terms of the ebb and flow of positions. With the 33 new positions, that gets us down to a much more manageable number, and what we were shooting for was something in the range of 100 to 125 water systems per sanitarian. At that number, we can get our work done, we can get our inspections done on time. So that's sort of the frame of reference I've been using to explain that.
Right, but in answer to my question, I'm trying to get at the number of staffers you had at the optimal time versus the number of staffers you have now. And if you could also, well, let's start with that, and I have a follow-up.
Well, let's start and end with that, if you don't mind. It's kind of the third question we'd like to get on to. We've got two other questions we'd like to get back on the information
I would be
meeting
glad to send that
component
to
to
you.
House Bill
Do
70.
you know it offhand?
House Bill
I can send that
707.
to you.
House
Absolutely.
Bill 707 is what the meeting was mainly about today. I appreciate the inquiries about staffing levels. Do you have the answer to Representative Vitale's question?
So I will get back to you with the exact number of staff and how they've changed over the years.
Great.
If you would mind sharing that with my office also, we'd appreciate it. We
I
can
will give it to all
disseminate
of
that
you.
to the members.
Sure.
Representative Zimmerman.
Thank you, Mr. Chairman, and thanks for your testimony, Lisa. So, question, I'm understanding that EPA kind of sets a standard, a threshold for everything, and then every state needs to at least meet that threshold. So my question is, in this drinking water arena in Pennsylvania, what areas are you more stringent than EPA requires?
So there are a couple. surface water systems require full-blown filtration to remove pretty nasty pathogens. We have been more stringent from day one for surface water supplies, but it was for the reason that we led the nation in waterborne disease outbreaks in the 70s and into the early 80s. If folks remember back then, we had massive waterborne disease outbreaks associated with giardiasis in the Scranton area. In the northern tier, they were just everywhere. And because of that, we went out ahead of EPA with a Pennsylvania filter rule. And where we're different is we mandate filtration for all surface water systems. The federal level, for example, requires filtration, but it also allows filter plants to do other things to avoid filtration. So that's one example. And there are a couple of other ones.
Is there other areas?
Sure. So another area where we're a little more stringent comes to disinfectant residual requirements. One of our more recent rules, we redefined what detectable meant. Detectable used to mean 0.02, but through science and information that we obtained through the manufacturers of testing equipment, they said that's not a detectable level. That's really just measuring noise. There's nothing really there. So we raised that level to 0.2 to make it more scientifically valid. That's another example.
Thank you,
Is there
Representative
a way to
Zimmerman.
get a list of those to us somehow?
For
Where
absolutely.
areas that you're
For
actually
more stringent? Absolutely.
Thank you. Thank you, Mr. Chairman.
Thank you, thank you. Representative Daly.
Thank you, Chairman. You mentioned that, I think you said that you find about 100 new public water systems on an annual basis. Can you just explain how you find them and why you didn't know about them before?
That's an excellent question. A lot of the parts of the state are pretty remote parts of the state. When you're driving by a building, you can't readily, so there's no sign out there saying, I might be a public water system. Sometimes it's a little challenging to figure out if they might be. So we know to look for restaurants. We know to look for places of business. And oftentimes if we find those, we stop in. I like to think that we're polite and cordial when we're there. If folks find otherwise, I want to know about it. So if you are not sensing that DEP staff are treating you with respect, please get those complaints to me. But anyway, back to your question. So the first step usually is to have a conversation and try to figure out what is there, what are they doing, could they possibly meet the definition of a water system, and then we usually leave a survey with them and ask them to complete the survey and send it back to us. And that helps us figure out whether they meet those thresholds. So we don't regulate everybody that provides water to the public. They have to do it up, there has to be at least 25 people being served or 15 service connections if it's a community, at least 60 days out of the year.
Is the survey something you could share with
Absolutely.
the committee? That'd be-
Absolutely.
Thank you.
Thank you, Representative Daly. Representative Dosh, we didn't have time for your question earlier. Would you have a question for this presenter?
Just quick one. You cited incidents that happened decades ago and in Canada and stuff. Are we seeing a problem? I mean, our guys who have been having these wells for 80, 90 years and serving those communities have not had problems. And I'm just trying to figure out what's the problem you're trying to correct, because in Pennsylvania, we really aren't experiencing that kind of a thing. And when you use force, you said about your people showing up, but the Supreme Court has already stated that when a government agent shows up, it's implied use of force. And the kind of things that we heard here today don't bode well for what you were saying about being helpful. But what exactly are you what is the issue that you're trying to correct? Because
Sure.
we see, we've got experiences with 80, 90-year-old wells serving adequately with no problems.
Sure. No, very, very good question. So a lot of the work that we do is absolutely preventative. If you construct a well properly in the first place, it's more likely to be protective of shallow surface water, on-lot septic systems that may be malfunctioning, runoff from a nearby farm that has a lot of manure on it. So a lot of what we do is preventative in nature. We do see the need for boil water advisories practically every other week at some place across the state. So we are issuing water supply warnings somewhere across the state practically every other week. So we do encounter problems, and oftentimes
Are those,
it's...
excuse me, are
Yes.
those, like the ones that I've seen out west have generally been with municipal water systems? Is that correct?
So no, we do also issue water supply warnings at non-community water systems as well. And oftentimes it's because they've detected E. coli in their source water, or it's a facility that put treatment on and they had a treatment breakdown, so their disinfectant is no longer working. There could be a multitude of reasons, but we do have a lot of water supply warnings that
Do you have a
go
list
out
of
every
those?
week. I can certainly pull a list
I'd
for
love
you.
to, I'd love to see
you want the-
those warnings issued for the last year and
Sure.
who they were issued to, because the only ones I've seen out west have been to municipal water systems.
Sure.
Thank you. That would be,
So just getting back to the problem that we're trying to solve, we can't monitor for everything, and even the 90 contaminants that are mentioned that are required to monitor, some of those are surrogates. We rely on total coliform bacteria as the surrogate to tell us whether or not that water source is susceptible to all kinds of nasty pathogens, viruses, hepatitis, norovirus. There are tons of viruses that can survive in water, and if they are getting into shallow surface water through a malfunctioning septic system, they can definitely get into a person's well. The CDC has some really interesting statistics that I would be glad to share with you as well that talk about what they believe is the true incidence of illness across the country. Because I can tell you, not everybody that gets a stomach bug or has an intestinal issue goes to the doctor. And if they don't go to the doctor, there's no way to document how and why they got sick. Most folks just, brush that off that they ate something bad, when it certainly could have been something in their drinking water.
thank you.
Sure.
Thank you for joining us today. We appreciate it.
Sure.
Thank you to the members. My advice to the community at large, if you have a church and you have an official from the DEP show up at that church and they're not there to worship with you, but they're there to regulate you, don't sign a consent decree without consulting an attorney. And I would ask them to leave my property if they're there to try and regulate you. If they're there to worship, I'd invite them to stay. But if they're there to regulate, I ask them to leave and come back when they're ready to worship, because it's a church. You have First Amendment protections, and I wouldn't give those up to a bureaucrat sent to regulate. So this will be a continued debate, I'm sure. But it's interesting that it seems to have flared up more in the recent past when it's been a law that's been in effect since the 80s. So something's changed. We want to get to the bottom of what it is. So, motion to adjourn.
Very quick.
Representative Dash.
I just want to say also, you got to remember, you got Fourth Amendment rights against unlawful search and seizure.
Motion to adjourn, Representative Dash, second by Representative Zimmerman.